All right, we've got some breaking news. FBI Director Kash Patel just filed a defamation lawsuit against The Atlantic. The magazine published a report Friday accusing him of excessive drinking and regular absences. More than 24 sources, including current and former FBI officials, spoke with The Atlantic about Patel's alleged behavior. He denies the accusations.
If I'm not doing my job, if I'm not working, then how is it that the FBI delivered the safest America under President Trump's leadership in the history of our country? That we are not going to take this laying down? You want to attack my character? Come at me. Bring it on. I'll see you in court.
So you're going to sue them?
Absolutely. It's coming tomorrow.
So what is just happening right now? Kash Patel, Trump's most trusted enforcer, the man whose entire value was built on silence and proximity to power, has already confessed. Not through a leak or a press conference, through the most legally destructive mechanism in the American justice system. The trap was set, the jaws snapped shut, and the road from the West Wing to a federal penitentiary is now paved with his own words.
Director, the first time you saw Donald Trump's name was in the Epstein files. Did you close the files or keep reading?
I have reviewed not the entirety of the files, so
you haven't reviewed all of the Epstein files?
Personally, no. What I've been doing is been busy providing the safest country this country has seen in modern U.S. history in historic speed, because the men and women of the FBI are given the resources to reduce the homicide rate, to reduce the drug trafficking rate, to reduce the amount of children that are being trafficked, and the number of pedophiles.
It sounds like those children being trafficked would appreciate the director reviewing the files. You said you don't know the number of times Trump's name appears in the files, so it could at least be 1,000 times. Is that right?
The number is a total misleading factor. We have not released anyone's name in the Epstein files that has not been credible.
The interrogation that matters did not happen in a cable news studio where Patel could spin and deflect. It happened in the sterile, soundproofed, wood-paneled box of a federal grand jury chamber. Special counsel Jack Smith, the man tasked with excavating the truth about the Mar-a-Lago classified document situation, did not ask for a friendly chat. He issued a subpoena. He put Kash Patel, the loudest mouthpiece of the declassification story, under oath. No cameras, no handlers, no escape, just the cold, clean machinery of a prosecutor and a witness who has been legally cornered.
Brett, this has been breaking in the last hour or so. We are told that, according to Kash Patel, the FBI director, the prior bureau leadership obtained his phone records and phone records to current White House Chief of Staff Susie Wiles back in 2022 and 2023. This eventually led into the Jack Smith special counsel investigation into then former President Donald Trump. We're told that some of these records are just toll records, which don't have specific information other than times and dates. They don't have the actual content of calls, but two sources in the FBI say that Susie Wiles' attorney agreed to be recorded by FBI agents in 2023. She did not agree. We've reached out to her for comment. FBI Director Patel, in a statement to Fox News, calls this outrageous and deeply disturbing. And I will add, Brett, that we are told at least 10 Bureau employees have been fired just today.
And when that prosecutor asked the pivotal question, the one that would slice through all the public relations fog, Patel's response was not a denial. It was not a clarification. It was a 5-word legal statement that changes everything about his public persona. He said, "I invoke my Fifth Amendment privilege against self-incrimination."
On November 3rd, Trump administration official Kash Patel was compelled to testify before a grand jury. His testimony would cover the declassification of documents seized in the FBI's raid of Trump's home. Kash Patel worked in Trump's National Security Council in a top counterterrorism role, and went on to become a principal deputy to the Director of National Intelligence, Richard Grenell.
Pause there and let the implications sink in. A man who had appeared across every friendly media platform, who had co-authored the narrative that Donald Trump possessed some ability to declassify nuclear secrets with a thought, who had mocked the investigation as a witch hunt, who had positioned himself as the ultimate transparent defender of the administration. That same man, when placed in a room where lying is a felony, looked the United States government in the eye and formally declared that answering truthfully would provide evidence of his own criminal activity. He did not just stay quiet. He made a legal declaration that his honesty would implicate him. In that instant, the mask of the loyal soldier evaporated, and the face of a co-conspirator hiding from his own reflection was revealed. He handed Jack Smith a weapon more potent than any FBI raid could ever produce. The irrefutable certainty that Kash Patel has something devastating to conceal. Now, prosecutors do not distribute immunity agreements like party favors. They wield them as precision instruments. Faced with Patel's stonewalling, with his legally declared fear of self-incrimination, the special counsel's team executed a maneuver of surgical precision. They granted him use immunity. Understand what this is because it is not a get-out-of-jail-free card. It is a legal constraint disguised as a shield. Use immunity means that the specific words you utter in that grand jury room cannot be used directly against you in a subsequent prosecution. But it strips you completely of your right to remain silent. The Fifth Amendment is gone. The door is locked behind you. The message from the prosecution is brutally clear. You will no longer hide behind the Constitution. You will now speak. And if a single syllable of what you say is false, we will bury you under a perjury charge that will make your head spin. Immunity does not make you safe. It makes you a compelled narrator of your own potential crimes. For a man whose entire identity is forged from the myth of being the unbreakable loyalist, this was a profound blow. They did not physically force him into a confession booth. They legally compelled him into one. The grand jury chamber was transformed from a place of potential risk into a federally mandated confessional. He had to answer. He had no choice. And the substance of what he revealed in that sealed room is now the most significant secret in Washington, locked inside Volume 2 of Special Counsel Smith's final report. A document currently hidden from public view.
A federal judge has just permanently blocked the release of Special Counsel Jack Smith's report on President Trump's classified documents case. And that means Attorney General Pam Bondi and any attorney general after her cannot release or share the second volume of Smith's reports.
We do not need the verbatim transcript to grasp the magnitude of what he said. We can deduce it with considerable precision from the chain of reactions it has set off in the corridors of power. The most significant of these reactions burst forth from the United States Senate itself. Senators Adam Schiff and Dick Durbin, senior members on the Judiciary Committee, fired off a formal, urgent demand to the Attorney General. Their request was not gentle. It was not exploratory. It was a targeted request aimed directly at Patel's credibility. They demanded the immediate release of the portion of the Smith report dealing specifically with Kash Patel. Read their justification because it is a damning indictment wrapped in bureaucratic phrasing. They stated that the report contained key information and evidence pertaining to the nomination of Kash Patel as director of the FBI and was essential for assessing his truthfulness, trustworthiness, and regard for the protection of classified information. Let me translate that procedural language into plain reality. Truthfulness means they have reason to believe he lied. Trustworthiness means they suspect a fundamental betrayal of his oath. Regard for the protection of classified information means they possess evidence suggesting he negligently or criminally mishandled state secrets. The Senate of the United States is not asking for a character reference. It is raising serious concerns with the full gravity of its constitutional oversight power that the man currently running the FBI may be a perjurer and a national security hazard, and that the proof is sealed in his own immunized testimony. They are publicly signaling that the story Patel told the grand jury under the threat of prison is a universe apart from the story he and Trump have been telling to the American people. This single action, the Senate's formal pursuit of the sealed testimony, operates like a key turning in a massive lock, swinging open the gates to reveal the full scope of Patel's legal vulnerability. His situation is not defined by a single issue. It is a sprawling, interconnected web of potential criminal exposure, and each branch is now drawing scrutiny. Consider the foundational claim, the declassification narrative. In the court of public opinion, Patel has been the principal architect of the claim that Trump possessed a standing order that automatically declassified any document he removed from the Oval Office. It was the emotional core of their defense, a claim that supposedly transformed boxes of top-secret intelligence into presidential scrapbooks. But what if, under the crushing pressure of use immunity, facing a prosecutor who already possessed the actual documents and the testimony of career officials, Patel conceded reality? What if he admitted that no such standing order ever existed, that the established procedures were deliberately bypassed, and that the documents at Mar-a-Lago were knowingly treated as what they visibly were, highly classified materials stored in a bathroom and a ballroom? If that transcript contains those admissions, Patel has not merely undermined Trump's primary legal defense, he has potentially incriminated himself in a conspiracy to defraud the United States and obstruct a federal investigation. Every television appearance he made, every tweet he posted, every public statement promoting the declassification story now retroactively transforms into potential evidence for a false statements charge. Next, trace the issues back to the Epstein files matter. As FBI director, Patel took control of the most politically sensitive archive in living memory. His public testimony before Congress, where he minimized connections, justified redactions, and portrayed himself as a champion of transparency, now sits in the shadow of his immunized grand jury appearance. If, under that secret oath, he admitted to knowledge of or personal involvement in a coordinated strategy to slow walk, obscure, or selectively release information to shield powerful individuals, then his congressional statements undergo a fundamental change. They transform from political spin into the material of perjury. His administrative decisions as director, the personnel changes, the delayed releases, the frustrating non-responses cease to be managerial choices and become evidence of potential obstruction of justice. Then examine the FBI personnel actions. Patel's overhaul of the Bureau began with the removal of career officials, a campaign of personnel changes marketed as bureaucratic reform. The official narrative was performance improvement. Now, through sworn depositions and declarations from terminated agents filed in active federal civil lawsuits, a serious counter-narrative is crystallizing in the legal record. These are not anonymous complaints. These are sworn allegations, the most potent form of evidence in civil law, alleging that Patel privately conceded that many of his personnel actions were direct violations of federal employment statutes and internal FBI regulations. The legal documents contain claims that he acknowledged these firings were probably illegal and would inevitably trigger lawsuits, but that he proceeded regardless because the White House or the president himself demanded it. These are not partisan talking points. They are sworn allegations of admissions against interests sitting in federal court dockets, and they paint a portrait of a man who looked at the law, recognized he was about to violate it, and did it anyway on command. Finally, trace the thread to the January 6th pardon decisions. Patel's deep involvement in vetting and likely championing the sweeping pardons for January 6th participants, including violent offenders who assaulted police officers, positions him at the center of a potential inquiry into whether the pardon power was used as a tool to reward those who attacked the Capitol to overturn an election. Any immunized testimony that touches on conversations with Trump about employing the pardon power as a corrupt bargain would be grounds for a criminal investigation into conspiracy to obstruct an official proceeding. The pardon power is broad on paper, but conspiring to use it to shield an attack on democracy is a crime. Kash Patel is not a bystander to the Trump scandals. He is the central hub where every allegation of misconduct converges and intertwines. And at every single connection point, the documents, the Epstein matter, the personnel actions, the pardon decisions, there now exists a formalized, legalized record of his potential involvement. Compelled, immunized testimony sitting in a sealed report, sworn allegations of his own admissions lodged in federal civil suits, and official Senate concerns broadcast in formal letters. The machinery of accountability is no longer idling. It is moving. The judiciary is methodically performing its constitutional function. Every time a judge like Tanya Chutkan issues a ruling on a motion pertaining to January 6th or the limits of presidential immunity, she is affirming the foundational principle that the legal process applies to every single person, no matter their proximity to power. The very act of a federal court recognizing the legitimacy of Jack Smith's investigation, and by extension accepting the compelled, immunized testimony of a figure like Patel, is a significant step. It validates the evidence. It establishes the principle that even the director of the FBI is not above being compelled into a grand jury to account for his own behavior. The courts, through their rulings and their custodianship of this explosive evidence, are systematically clearing the legal obstacles and political defenses, creating a clear field where the factual architecture of the case is visible to everyone. This meticulous judicial groundwork sets the stage for the ultimate prosecutorial tactic, the squeeze. Kash Patel is the ideal subject for this pressure strategy. He is senior enough to know the details of every operation, every motive, every instruction. Yet he is not constitutionally shielded like a sitting president. He is vulnerable. Federal prosecutors can now walk into a room and lay before him a multi-count indictment, a broad array of charges drawn directly from his own immunized admissions, the civil suit allegations from his former colleagues, and the contradictions in his public testimony. Perjury, obstruction of justice, conspiracy to defraud the United States, abuse of power, violations of federal personnel laws. The charging document could be enormous, a career-ending, life-changing edifice of legal exposure. Then they will present the choice, and it will not be gentle. They will say, you can fight this. You, a former FBI director, can find yourself in the defendant's chair of a federal courtroom with your own words, spoken under immunity, and your colleagues' sworn statements used as the primary weapons against you. The statistical likelihood is not a minor consequence. It is a decade or more inside a federal penitentiary. The sound of the cell door closing will be the last sound you register as a free man for a very long time. Or, and here the room will grow very quiet, you can cooperate. You can provide exhaustive, detailed, and independently corroborated testimony about every single instruction you ever received from Donald Trump. You can illuminate for us the documents, explain the intent behind the Epstein file handling, detail the logic of the personnel actions, and unpack the mechanics of the pardon decisions. You can become the key witness who translates the chaotic public pronouncements into the clear picture that underpinned them. In exchange for this complete and total account, we will entertain a plea to substantially lesser charges, and crucially, we will advocate for significant leniency at your sentencing hearing. For Patel, a man whose public brand is synonymous with fierce, untouchable loyalty, this moment represents a fundamental rupture. The foundation of his identity is built on being the enforcer, the silent warrior, the one who never breaks. But the primal instinct for self-preservation is a force that political allegiance rarely survives. When the abstract concept of loyalty is weighed against the concrete reality of spending your remaining healthy years in a federal facility, while the man you protected continues to enjoy the comfort of his private clubs and rallies, the calculation of blind devotion collapses. The romanticized narrative of the loyal soldier dissolves the instant the choice becomes you in an orange jumpsuit, while he delivers a fiery speech about your betrayal to a cheering crowd. If Patel chooses survival, and the entire history of prosecuted presidential insiders from John Dean to Michael Cohen to Mark Meadows suggests that when the stakes become real, they almost always do, the impact will be enormous on the presidency he was installed to protect. His corroborated testimony would provide the single missing element that many observers have argued the special counsel's body of evidence has thus far lacked for the absolute highest level, a direct eyewitness account of Donald Trump's knowing criminal intent. Patel could be the voice that tells a jury, yes, the president fully understood the documents were classified. He instructed me to propagate the declassification story publicly as a cover. He personally directed the slow walking of the Epstein responses to protect certain associates. He ordered me to remove those specific career employees as an act of political vengeance, knowing perfectly well it was a violation of the law. This transforms a powerful yet circumstantial case into a direct, eyewitness-driven prosecutorial challenge that is very difficult to defend against. The entire defensive structure of plausible deniability crumbles when the man who stood directly behind the decision-maker testifies that the president meticulously planned every contested detail. The Senate Democrats' dogged pursuit of the sealed Smith report is the opening political statement in this final unfolding battle. They are not merely seeking to embarrass an FBI director before the cameras. They are building the public foundational record for what may become the ultimate constitutional confrontation of this era. They are methodically gathering the evidence, the immunized secrets, the sworn allegations from the personnel actions, the official congressional demands. This evidence will serve a dual purpose. It will either form the ironclad basis for an impeachment proceeding in the House, or it will create the public foundation for a sweeping post-presidency accountability effort that cannot be dismissed as partisan theater. These senators understand with clarity that Patel's forced admissions are the key to understanding the entire scandal. They are the decoder ring that can finally translate Trump's chaotic public statements and reveal them for what they allegedly were, a deliberate smokescreen designed to obscure a systematic pattern of misconduct. Kash Patel constructed his entire position of power on a foundation of secrets and an unbreakable code of silence. The American justice system, moving with the slow, grinding, but persistent force of law, has now undermined that foundation. The original use immunity order was the initial action planted in the structural core of his silence. The sealed testimony that followed was the contained detonation that changed the internal dynamics. The Senate's formal pursuit is the pressure release, and the mounting civil lawsuits from the agents he removed are the visible cracks spreading across every remaining wall of his position. Each development reveals more of what lies beneath where his defense once stood. The path to serious legal jeopardy is no longer a speculative outcome debated on panel shows. It is a tangible procedural reality being actively constructed by judges who enforce the law without passion or prejudice, by senators who execute their constitutional oversight duties, and by career prosecutors who follow the evidentiary leads without fear, even when those leads point directly to the Director's Office of the Federal Bureau of Investigation. Patel did not merely witness contested actions from a safe distance. According to the legal record now taking shape in multiple jurisdictions, he actively participated in them, orchestrated parts of them, and then, under the pressure of the legal system, he spoke to the core elements of those actions in a sealed room. The court has not only identified a path to accountability, it has provided the map, clarified the process, and illuminated the way forward. All that remains now is the final inevitable journey.